Hi, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Today I want to talk about why you should never make a deal on a napkin. But first I want to say, if you want to discuss anything you're going to hear today, you want to discuss your business, or you think you might have a potential case, all you have to do is go to jdelaw.nyc/consult. That's jdelaw.nyc/consult to book that 10-minute phone or 30-minute in-person consultation with me. Now, why should you never make a napkin deal? Well, this comes out of a consultation I had with a potential, actually not even a consultation. I have a client, and what they did was they had some money to burn, literally their words, and they wanted to buy into a local business. So they actually handed over their car and paid a six-figure sum to buy 50% of the shares. But basically, they didn't get anything really in writing except the rudimentary deal, which was a few lines on a piece of paper. Now, they didn't get a receipt showing that they paid the money. They didn't get their stock shares showing that they're a member of the corporation. They didn't really get anything except this little handwritten, not even handwritten, but this short little deal. And what's even better about the deal is it lists one person as the other owner, but they had to make their payments to a third person. So they didn't know if they were buying that person's shares, if this is some kind of deal that's not above board. They don't know any of that. Okay, they weren't protected by an attorney. They don't know what they bought. The purchase price doesn't even match up with what's on the piece of paper. And now that it's around tax time, they want to know, well, where's my stocks? What am I showing to my accountant? You know, it's been 6 months. They haven't received any money out of the business. They don't know anything about what's going on with the business. And I have to try and untangle it for them. Okay? This is why you don't do napkin deals. Because you need everything spelled out. You need proof of everything that's in the contract. Okay? If you pay money, you want to show that they received the money, right? You want to be able to prove that they have the money, so you should be able to get your shares or whatever the deal is. Okay? You need to prove it, because when you get to court saying this was the deal we agreed on, here's the napkin, or we verbally agreed on it, it's very hard to prove your case. And a lot of times, if they really are sophisticated on the other side and they knew what they were doing when they got you to do it, you could be out 6 figures. You could be out 5 figures, 7 figures, whatever the deal is, if you're not sophisticated or if you're not protected by an attorney. Okay? Because then comes he said, she said. And the court cannot make a ruling on he said, she said. So when in doubt, they're going to rule against the person, rule for the person being sued, because they're saying the other side can't prove their case. This is why you have to get every agreement in writing. This is why you have to be able to prove your case from start to finish. So do things right the first time. Get the attorney. Get the contract in writing. Get the receipts. And make sure that at the end of the day, that if something goes wrong, you're covered. All right, if you have any questions about what you heard today, you want to discuss a possible case, or you want to just talk about your business, go to jdelaw.nyc/consult. That's jdelaw.nyc/consult to book that 10-minute phone or 30-minute in-person consultation with me. All right, once again, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Thanks for watching and listening.